In this video, we take a look at the latest XRP news. Will XRP be able to fly to the moon? Right answer. Despite the pessimistic market outlook, positive price expectations for XRP continue to emerge, with most price forecasts forecasting XRP to exceed its all-time high reached in January 2018. While XRP price forecasts seem to be flooding the crypto market, the unresolved issue is when these price expectations will come to fruition. In view of the above, we thought it appropriate to ask Google Bard about the potential timescale for XRP to return to its all-time high price. For background, Bard is a Google artificial intelligence (AI) chatbot model. It, like Chat, might be utilized to acquire insight into a variety of urgent situations. It has always been applicable in the cryptosphere. The AU model fails to provide a particular timetable for a prospective increase in the value of XRP. The chatbot did, however, recognize that some crypto experts and elite chartists seem to believe that the XRP re-rise will take place between 2024 and 2025, while others predicted that it would take many years before the bull run began. Bard, on its part, identified certain critical events or occurrences that might have a significant impact on XRP price swing. The outcome of the U.S. Securities and Exchange Commission (SEC) v. SU Ripple legal dispute, the overall state of the global economy, technological advancements in the cryptosphere, shared market sentiments, and price changes that could be elicited due to changes in demand and supply, according to Google's A model. Ripple recently achieved a significant legal victory when the U.S. regulatory body's demand for an interlocutory appeal was denied. Ripple now has a stronger chance of winning the legal battle, which might raise the price of XRP in the long term. The global economy affects more than just physical and monetary assets. It also has an effect on digital asset values such as XRP. The global economic outlook remains a critical predictor of XRP's future price movement. Improved technical advancements in the crypto world, particularly those impacting Ripple and XRP, may result in an increase in the price of XRP. In depth, Google Bard examined the possible effects of market sentiment on XRP price rise. Positive market emotions, it is widely assumed in the crypto world, would support digital asset values, while negative ones will result in falls. Demand and supply were both mentioned as being important. When supply exceeds demand, it indicates a lack of interest, resulting in price reductions. When demand exceeds supply, it implies that the tokens are in great demand, and their values rise. This comparison was ascribed to XRP by the chatbot. Bard closed by underlining the impacts of volatility and fluctuation in the cryptocurrency market, asking investors to do their homework before investing in any cryptocurrency. In the midst of the long-running legal fight between Ripple and the U.S. Securities and Exchange Commission (SEC), another war rages on social media between those who feel the current court ruling has no significant influence on the cryptocurrency business and others who disagree. In an X post published on October 6, former Sec Attorney John Reed Stark referred to Judge Annalisa Torres' recent denial of the agency's motion for an interlocutory appeal as a Pyrrhic victory at best for the XRP team, calling it a Pyrrhic victory at best for the XRP team. According to Stark, the governing body will still undoubtedly appeal the decision after the trial, and I believe have a good chance of winning due to the fact that the judge has specifically deemed her decision as not precedent for the rest of the Greece cryptoverse. Furthermore, he dismissed Judge Torres' most recent decision as precedent on the issue of whether tokens are securities, claiming that the court did not hold that offers and sales on a digital asset exchange cannot create a reasonable expectation of profits based on the efforts of others. In particular, the former attorney for the SEC said that the court held that based on the totality of the circumstances in this case, including an examination of the facts, circumstances, and economic realities of the transactions, Ripple's programmatic sales could not lead investors to reasonably expect profits from Ripple's efforts. Emphasis in original. Stuart Alderoty, the blockchain company's chief legal officer, commented on Stark's post, saying, "Agree to disagree on the legal impact of Judge Torres' rulings, but you also seem to be saying that XRP uniquely stands as the only digital asset other than BC with judicial clarity as a non-security. We're on the same page now." Simultaneously, after the judge denied an interlocutory appeal motion, lawyer Jeremy Hogan listed a number of possible outcomes for the Ripple v. SEC case, including the regulator moving forward with a trial next April against the individual defendants and an appeal of the case no sooner than 2025, with an appellate ruling no earlier than 2026. Other possibilities include the SEC settling the case against the individual defendants and proceeding with obtaining a final judgment against Ripple, and then appeal, as well as the SEC settling all litigation against Ripple and the individual defendants. During a settlement conference on April 16, 2024. On 6 October 2023, John Reed Stark, a regulatory compliance specialist in the digital arena with a 15-year stint as an cease enforcement attorney, turned to social media platform X, previously known as Twitter, to offer his thoughts on Judge Torres' recent ruling regarding the SEC and X. Stark underlined that the judge's decision to dismiss the SEC's interlocutory appeal also indicated that her earlier summary judgment should not be regarded as establishing a legal precedent unless the circumstances of a new case are similar. Stark pointed out that, although this may seem to be a little success for the XRP team, it might ultimately be a hollow victory. He expects the SEC will appeal the verdict after the trial and has a decent chance of prevailing. Judge Torres clearly said that her judgment is not to be regarded a precedent for subsequent instances in the Bitcoin industry, according to Stark. Stark also praised John Deaton and the XRP team for standing up to the SEC's unilateral law-making techniques. He stated his displeasure with attorneys who switch between law firms and the SEC, implying that such attorneys are unlikely to question the status quo owing to possible conflicts of interest. Stark commended Deaton's team for exposing the SEC's unappreciated work in addressing less publicized but critical matters such as microcap fraud and penny stock fraud. Stark, on the other hand, was emphatic in noting that Judge Torres' Ripple ruling should not be referenced as a precedent on whether tokens are securities. He emphasized the judge's unequivocal statements that her judgments were based on the Ripple case's unique facts and circumstances. Judge Torres rejected the SEC's assertion that the issues posed in the case are crucial legal issues with far-reaching repercussions for several other cases in his judgment, denying the SEC's motion for interlocutory appeal. She stressed that her judgments are based on applying the Howey test to the facts and circumstances relevant to this Ripple instance. Judge Torres went on to add that the SEC's citations to other enforcement cases involving other digital assets and firms are not directly comparable owing to differences in facts and economic circumstances. She further clarified the SEC's interpretation of her findings, indicating that her order should not be seen as establishing a precedent for future digital asset disputes. The SEC had specifically tried to determine whether an issuer's activity on cryptocurrency trading platforms may provide investors with a reasonable expectation of profit. Judge Torres explained that her decision was based on the whole set of facts and economic reality underlying Ripple's programmatic sales rather than a blanket pronouncement on the subject. Any lawyer who uses this ruling as a general rule on token regulation risks ethical ramifications for breaching their duty of transparency, according to Stark. This is because Judge Torres has said unequivocally that her ruling has no precedential weight, save in very limited cases when the facts are similar. Stark continued by warning that referencing Court Torres' ruling in a larger context would be an ethical breach, since the court has explicitly declared that her decision should not be seen as having universal validity.